Unbundling property rights. In England, the boundaries of property are often based on enduring natural objects and contours of the land, such as rocks, trees, or hills. In the United States, much of the land was surveyed and divided into uniform parcels. In the countryside and in towns, superscript 56, it reads: a grid for land boundaries. Rectangular survey was an innovation that spread in the British Empire during the 19th century, replacing the demarcation of land boundaries by natural objects such as trees and rocks. Meets and bounds. Back to the text. Standardizing property simplifies comparing one property to another. Easy comparison of property opens the real estate market to broader competition because potential buyers need less information to compare the value of one property relative to another. Besides real estate, uniformity lubricates sales for stocks, bonds, wheat, oil, and many other goods. Conversely, inconsistent bundles of rights make properties incomparable to each other, so prices must be negotiated individually. Thus, one share of stock issued by Honda is the same as another share of the same class of stock. Honda shares have a public price in the stock market, at which they can be bought and sold. In contrast, investment banks have created bundles of standardized real estate mortgages, derivatives, whose prices are individually negotiated. Unlike stock market prices, individually negotiated prices for securities are not public information. Most people do not know the price at which such a security last sold. When securities prices plummeted in the financial meltdown of 2008, Harvard University held many unstandardized securities without a public price, so it did not know how much value its portfolio had lost. In general, the owners of property possess a bundle of rights. To standardize property, the law must restrict the owner's ability to repackage these rights. The owner of a good may have rights W, X, Y, and Z over it. The owner may want to unbundle these rights and sell W and X to one person while retaining Y and Z for himself. Sometimes, however, law only allows sales of the complete bundle. For example, the owner of a city lot can sell it as a whole, but city regulations may prevent him from cutting it in half and selling half of it. Zoning illustrates specific regulations that prevent unbundling some property rights. A deeper question is whether something in the nature of property generally limits or restricts unbundling. To illustrate what is at stake, assume that capital A inherits his family's heirloom pocket watch. Capital B, who is capital A's brother, would like to wear the watch to a Christmas party each year. Capital B pays some money to capital A in exchange for capital A's promise to let capital B wear the watch every Christmas. Capital A's refusal to let B wear the watch on Christmas in a future year would breach their contract. So capital B could sue capital A for money damages. Continuing the example, assume that capital A sells the watch to capital C. In making the sale, capital A tells capital C nothing about capital B. Capital C remains ignorant about capital A's contract with capital B until Christmas approaches, and capital B asks capital C for the watch to wear. Capital C refuses. What can capital B do? Nothing to capital C. Capital C does not have to let capital B wear the watch on Christmas. Capital B's only available remedy is to sue capital A for compensatory damages for breach of contract. As this example illustrates, the contract between capital A and capital B does not give capital B security that he will always get to wear the watch on Christmas. What B wants is a right to use the watch on Christmas that he can assert against anyone who owns the watch. Capital B might take a novel legal approach in an attempt to get security. Let capital A sell capital B the use rights over the watch on Christmas, and let capital A retain all of the rights over the watch. If capital A did not own use rights for the watch on Christmas, then presumably capital A could not sell those rights to anyone else. Further, anyone who tried to prevent capital B from using the watch on Christmas would presumably interfere with his property rights. Specifically, if capital C refused to let capital B use the watch on Christmas, then capital B could sue capital C for trespass and obtain a specific performance. We will explain these terms in more detail in chapters 8 and 9. Notice what happens when capital A and capital B replace capital A's contractual promise to capital B with capital A's sale of use rights to capital B. Damages are the usual remedy for breach of contract. Hence, B's contractual rights to wear the watch on Christmas is protected by capital A's liability to pay damages for breach. In contrast, injunctions are the usual remedy for trespass on property rights. Hence, capital B's ownership of the right to wear the watch on Christmas is protected by his ability to obtain an order from the court requiring capital C to allow capital B to wear the watch on Christmas. The example of the watch illustrates how unbundling can hinder commerce. Specifically, if unbundling is allowed, capital C would be uncertain exactly what rights he acquired by buying the watch on capital A, which would dampen capital C's interest in buying the watch. A vigorous market requires certainty of buyers concerning the rights that they acquire. This example raises the general question: Can the owner of property who has a bundle of rights rearrange the bundle of rights freely, transfer them as he wishes, and force courts to protect the transfer of rights by injunctions? While this problem seldom arises with watches or similar objects, it often arises with real estate. To illustrate, assume that I own my family's ancestral home, Blackacre, and I want to assure that no one will ever use it for purposes other than a residence. To secure this end, I would like to remove the development rights from the bundle of ownership rights. Can I do it? According to the common law of property, I can only restrict the use by the future owners of Blackacre for a limited period of time. See the preceding discussion of the rule against perpetuities. In general, an owner cannot freely unbundle and repackage real property rights in common law. Similarly, civil law systems in countries like France go beyond these common law restrictions by enumerating rights of real property that the owners cannot change. According to the civil law tradition, the enumerated rights attach to the property itself, not to the person who happens to own the property. Superscript 58, it reads, in legal language, numerous clauses refers to a restricted list of rights, including property rights. In property, these rights are in rem, meaning that they attach to the property regardless of its owner, whereas contract rights are in personam, meaning that they attach to the particular people who made the contract. See the article by Thomas Merrill and Henry Smith noted at the end of chapter 4. Back to the text. Another important kind of property that provokes disputes about bundling and unbundling is the corporation. The stockholders of a corporation are its legal owners. Each share of stock traditionally conveys to its owner the right to one vote at stockholders' meetings. In recent years, however, some corporations have created new kinds of stock that do not give voting rights to their owners. There are many other examples where corporations have unbundled and rearranged the traditional rights enjoyed by their owners. Instead of entangling ourselves in the details of real estate or corporate law, we must focus on the general point underlying these controversies. In the example of the heirloom watch, the fundamental issue is whether the owner of property can give several different people rights over it that they can enforce by specific performance against anyone who interferes. Economic efficiency generally favors allowing unbundling whenever it increases the market value of the property, and prohibiting unbundling when it decreases the market value of the property. Property owners generally want to maximize its market value, and they are better situated than the state to know how to do this. Consequently, the State seldom has reason to prevent owners who want to unbundle from doing so. Recall, however, our previous discussion about the anti-commons. Unbundling may impose future costs on those who would like to repackage the rights into a new configuration. Insofar as an economic argument against unbundling, insofar as there is an economic argument against unbundling, it is based on this desire to minimize future costs of assembling those rights into a more viable whole. Some theorists have argued that individuals can sometimes increase the value of their own property by unbundling in ways that increase transaction costs for the sale of other properties. To illustrate, a standard form of contract lowers the bargaining costs of everyone in an industry. One seller who departs from the standard form, one seller who departs from the standard form reduces standardization, which imposes costs on other sellers. In general, a common pool of knowledge about contracts lowers transaction costs of exchange, and unbundling drains the common pool. This view implies that property law requires constraints against fragmentation and particularization. This argument, however, is unconvincing. Much of contract law imposes rules that apply unless the parties stipulate otherwise in the contract. See our discussion of default rules in Chapter 8. The state does not have to police contracts to make sure that they remain sufficiently standardized. State requirements of standardized contracts are typically misguided for the same reason that state restrictions on unbundling property are misguided. The law should obligate sellers to disclose improbable restrictions on ownership due to past transactions, but as long as the parties understand what they are purchasing. The law should generally enforce agreements to unbundled property rights.